So hello everyone, this is Akshay Nagpal and I welcome you all on this channel. Today we are going to discuss about NCLT and NCLAT, which is your one of the chapters of CA Final Law, and you can expect 3 to 4 marks from this chapter. And in the previous 3 to 4 attempts, a particular question from section number 420 to section number 423 is coming, and I expect the particular question from that either in your objective type question or your subjective type question to come in your upcoming attempt as well. So we'll focus more on those sections where they talk about the time limit specifically and all the things in between, that the expeditious disposal of particular time limit, and there is a revision of the order if the mistake is apparent on record within which time limit, and how can you appeal to NCLAT or to the Supreme Court and all. So there are section number 420 to section number 423, which are of utmost importance, and you can expect the question from those sections as well. Those sections. So yeah, plus section number 424 is there, which talks about the powers of NCLT and NCLAT. So that section is also important for your syllabus. Section number 419 is excluded from your syllabus by the notification that came in July 2019. So we will not do section number 419. And section number 434 is there in your study material, but the practical applicability of that section is not relevant. But we will do that anyway because institute, So yes, we'll do all these sections in your study material except for section number 419. And so yeah, let's begin. But before that, I will recommend you to go to all the classes of miscellaneous provisions chapter. You can see that in your I column, and 3 parts have already been uploaded. The remaining 2 parts will be uploaded very soon. So yeah, that's that. Plus, you can expect peer review chapter in the upcoming week as well. Peer review is the amended chapter, and we will be covering that whole chapter in this channel only. All right. So yeah, let's begin this chapter first, and we will be trying to cover the whole chapter in limited time. So I have made I've made this PDF for 6 to 7 pages, and all the things are covered comprehensively along with examples. So yes, let's start. First, let me give you an introduction of NCLT and NCLAT. As you can see in your screen, that earlier scenario was that there were number of boards which handled number of various cases. For example, Company Law Board was there, and BIFR was there, and the Appellate Authority for Industrial and Financial Reconstruction was there. So these all institutes were there, and now they are all clubbed into NCLT since 2016, and all the cases related to the company, either in this act or in your IBC 2016, Insolvency and Bankruptcy Code 2016, are being handled by NCLT only. So yes, NCLT is the appellate authority, is the ultimate appellate authority for all the cases which are actually about the company, which are actually concerning the company. So if any person is aggrieved, if the company is aggrieved by the order of the registrar or the inspector or the any other authority, then they can appeal to NCLT only from 2016 onwards. And section number 434 was the transitory provision section. That's why its practical importance is not there, but we will still study that section 434. So it's a lengthy section, and I have made a particular table for that section as well. So yes, let's do the introduction first. As I've already told you, if there is a particular you can see the diagram that I have made. It's CLB plus BIFR plus Appellate Authority for IADF, Industrial and Financial Reconstruction are now clubbed and made into NCLT. So NCLT is the final appellate authority right now, like after 2016. Final appellate authority, by that I mean that the only appellate authority for the companies. If there is a company that wants to appeal against the orders, then they will head to the NCLT only. All right. So yes, the C point is there. The Companies Act 2013 provides for the constitution of NCLT and NCLAT. So 2013 Companies Act 2013 contained this provision that the NCLT will be constituted, but it was constituted in 2016 only. So till 2016, there were all CLB, BIFR, and Appellate Authority for IADF Reconstruction were there that were handling all the cases. So yes, since 2016, the NCLT was incorporated, and the principal bench is in New Delhi, and all the other benches are in the other relevant states. So yes, NCLT is set up to bring all the lawsuits pertaining to companies under one body. So I've already told you that all the cases related to all the lawsuits pertaining to the companies are clubbed, are only be appealable to the NCLT now. So yes, let me give you a particular background of this as well, that there is an adjudicating authority and there is an appellate authority. For example, in the case of companies, the adjudicating authority will be the registrar, and for the appellate authority, the appellate authority will always be the NCLT since 2016. All right, so NCLT and NCLAT will have judicial and technical members. So yes, the constitution is there in your section number 409, 409 or 410. We will see, and we will see how what is the constitution of NCLT and NCLAT? NCLT is constituted by these are all constituted by central government only, and there is a president and the chairperson for respectively for NCLT and NCLAT, and technical and judicial members are also there. The comprehensive list is not given in your the comprehensive list, and qualification is not given in your study material, so we will not study that. We'll only see that how many members should be there in your NCLT or NCLAT as given further. All right, so notification SO 1936E dated 1st June 2016, read with section number 434 subsection 1 clause A. 434 subsection 1 is the transitory provision section of the Companies Act 2013 as an appointed date. So appointed date shall be 1st June 2016. So the date is 1st June 2016. As on that date, all the cases which were pending before CLB or and all will be transferred to NCLT, subject to some provisions, subject to some exceptions, which we will cover in section number 434 in the later part. All right. So yes, notification SO 1936 gives the appointed date, that is 1st June 2016. All matters pending with CLB shall be transferred to NCLT and shall be disposed by NCLT in accordance with the provisions of Companies Act 2013. So yes, as I've already told you that this is a transitory provision, and that as per the notification SO 1936, this is the appointed date, 1st June 2016. All right. So yes, the central government shall by notification constitute with effect from such date as may be specified therein a tribunal. Tribunal here it means NCLT consisting of a president. So as you can so means that NCLT will be constituted by the central government and president, and such number of judicial and technical members will be the constitution, basically the constituted parties of the NCLT. And NCLT, for the knowledge sake, that there will be a chairperson, and the other judicial and technical members will always be there in NCLT as well. So if a particular person is aggrieved by the NCLT order, then that company shall head to the NCLAT within 45 days. We will study that in section number 421. All right. So who can appeal to NCLAT? Who can appeal to NCLAT? As I've already told you that any appeals against the orders of the NCLT shall be appealable to the NCLAT. All right. Or there is other things given in your study mat as well, that if the NAFRA order is there, NAFRA is constituted under section number 132 for the auditors of the specific companies. The NAFRA is constituted for basically keeping the quality in check. All right, for the auditors. So yes, if the NAFRA gives an order, then that order shall also be appealable to NCLAT. This is for your knowledge purpose, but can be asked in MCQ as well. So yes, second point is any direction, decision, or order referred to in section number 53A of the Competition Act 2002 in accordance with the provisions of that act. So as per the point number G, who can appeal to NCLAT? There are three parties given. First is if the NCLT orders, then the same order can be appealable with the with the NCLAT. And the second party is NAFRA. If the NAFRA gives an order and the party is aggrieved by that order, then the aggrieved party can appeal to NCLAT. And the third one is as per the section number 53A of the Competition Act. All right, if any decision, direction, or order is given as per the section number 53A of the Competition Act, then that order, then the person aggrieved by that order can also appeal to NCLAT. All right. So I have already written here is read with section number 421. Section number 421 talks only about these things, that appeal against the order of NCLT. Only this thing is covered in section number 421. All right. So yes, H point, this is a general point, that a one-stop solution for all the companies is NCLT now. All right, as per the Companies Act and as per the IBC Act as well. IBC only for the companies. All right, that is a main catch here. All right, and in your syllabus also you can see the companies sections only. The other sections are not yet notified for your syllabus. All right. So first page is covered. Section number 407 talks about the definitions. Chairperson definition is chairperson means the chairperson of the appellate authority. NCLAT का member होता है chairperson, and the president means the president of the NCLT. So NCLT and NCLAT. NCLT contains the president, judicial member, and technical member, and NCLAT is constituted by chairperson, judicial member, and technical members. So yeah, this is that only. Not very important, but you should know. All right, member here means a member, whether judicial member or technical member of the tribunal, that is NCLT or the appellate tribunal, NCLAT, and member includes the president or the chairperson as the case may be, president of NCLT and chairperson of NCLAT. All right, so judicial member means a member of the tribunal and the appellate tribunal appointed as such and includes the president or chairperson. So judicial member can only be a president or chairperson. That is, technical member cannot be the chairperson or the president. That is the point to be noted here. And technical member basically have an experience in your CA. A CA can be a technical member, a CMA, CMA can be a technical member with a particular experience which is not included in your exams. So yes, which is not asked in your exams and not in your study material as well. So yes, a judicial member means an advocate or a high court judge, वगैरह. So that is the thing to not be discussed, not to be asked in questions. So yes, we'll ignore that. All right. So yes, section number 419 is out of syllabus, as I've already told you, as per the notification that was given in July 2019. No, since November 19, the same was excluded from your syllabus. So we will not study that. Section number 420 to section number 423 are very important for your exams, as I've already mentioned there. So yes, we will study this whole series of section through this chart that I've created, and you can have you can also refer to the provisions I have mentioned below. So first we will study through this chart only. All right. So NCLT is there. If a company is aggrieved by the order of adjudicating authority, then the company can appeal to NCLT. Then you will have to study section number 420 and section number 422. Section number 420 simply says that reasonable opportunity of being heard should be given to all the parties, and a copy of order of all the if NCLT passes an order after giving an opportunity of being heard and all of that, all of the proceedings here under, then it shall have to send a copy of order to all the parties concerned as well. All right. And section number 420 contains one other provision as well, which talks about amendment in 2 years. If the order is amended, if the order needs to be amended because of the particular mistake that is apparent from record, for example, if the order is passed and a particular mistake is done by the NCLT member, then the same can be rectified, can be amended within 2 years. A 2 years time limit is given, but there is an exclusion that if the same is appealed to the further authority, that is NCLAT, then the same cannot be amended. All right, this was the thing. Plus one more thing is there, that if the order is passed, if the order by NCLT is passed by the consent of all the parties concerned, then the same order cannot be appealable. This was asked in January exams, so I thought of mentioning to you that as well. All right. So yes, amendment can be there in 2 years from the date of the order, and section number 420 contains that provision. Section number 422 talks about the expeditious disposal of the order by the NCLT, and NCLAT also contains that provision. So yes, we will study that as well. So after NCLT, if the NCLT passes an order and the company, either the company or the other authority concerned is aggrieved by the order of NCLT, then within 45 days, the same party shall have to appeal to NCLAT, further appeal to NCLAT, and the condonation can be given for 45 days at the discretion of NCLAT only. If there is a particular reason, there is a sufficient reason that the NCLAT may get a logic of. All right. So it is on the discretion of NCLAT that the further 45 days can be given to the party aggrieved. Either the company can be the party or the other party. For example, the registrar can also be the other party that appeals to NCLAT, not only the company. All right. So yes, there is no particular thing given here about the amendment of 2 years in section number 421. So you will not have to remember that. All right. Section number 420 contains 3 things, as I've already told you: reasonable opportunity of being heard, send a copy of order of to all the parties concerned, and amendment in 2 years. Okay. And NCLAT, one party cannot appeal to NCLAT if, I've already told you that if the order of NCLT was passed with the consent of all the parties concerned, then none of the party can appeal to NCLT. This is covered in your section number 421. And one second, third point here: if order passed by NCLT with consent of all the parties, the same is non-appealable. All right. This was asked in January exams, as I've already told you. So yes, once the NCLAT order is passed, then the same thing, section number 422 talks about the expeditious disposal of the same, the expeditious disposal of the case by the NCLAT and NCLT as well within 90 days, and the further 3 months can also be given. Sorry, I have reversed the equation. First, 3 months. Within 3 months, let me see the provision first. I don't want to give wrong indication. Yeah, speedy disposal, disposed of by it as expeditiously as possible, and every endeavor shall be made by the tribunal or the appellate tribunal, that is NCLT or NCLAT as the case may be, for the disposal of such application or petition or appeal within 3 months. So with 3 months time is given to NCLT and NCLAT to dispose of the case. But if they couldn't dispose of within 3 months, then after recording the reasons for the same, for not disposing the application for not disposing of the application or the petition or the appeal as the case may be, then further 90 days can also be taken by the president or the chairperson respectively for NCLT and NCLAT. All right. So the limit here is 3 months plus 90 days. After 90 days only after giving the after recording the reasons by them. All right. This covers our section number 422 and all. Section number 420 is already covered, which talks about basically one thing mainly, that is amendment in 2 years if the mistake is apparent from the record. 422 talks about basically the expeditious disposal of the case, 3 months plus 90 days. And section number 421 talks about the appeal if the order of NCLT is aggrieving with the other parties. Then 45 days plus 45 days is given to the aggrieved party. All right. If after the order of NCLAT there is a party aggrieved on the question of law, only on the question of law, then within 60 days, the same can be filed with the Supreme Court, and 60 days discretion also can be given after giving the opportunity of being heard. All right. So let's read it very quickly. This we have already covered. Amendment part, ROBH, reasonable opportunity of being heard, and sending a copy of order to all the parties concerned. I have highlighted, I have used the blue color for those sections, which is basically common for NCLT and NCLAT both. So reasonable opportunity of being heard and sending a copy of order to all the parties concerned is there in section 420 and section 421 both. All right. So yes. Now second point says that who can appeal. Point G you can refer for your knowledge, but as per section number 421, only any person aggrieved by the order of NCLT can appeal for the can be appealed to the NCLAT. All right. And within 45 days, the time limit is there within 45 days, and further limit of 45 days if NCLAT is satisfied that the appellant was prevented by sufficient cause from filing of appeal within that period. It is up to NCLAT. So summarizingly, that. All right. Section number 422 talks about the expeditious disposal. There is a particular chart here as well about the section number 421. This was taken wholly from your study material. So yes, section number 422 talks about expeditious disposal. We have already covered that, and you can refer to the chart as well. 3 months, 90 days. All right. Section number 423 basically talks about the Supreme Court. We have already covered the 60 days time limit is given there. All right. So let's head to the example now. We have already covered 3 pages out of our 7 pages, and we will be able to cover 4th page, which talks about basically the examples. Yes. So let's head to the example. An order made by NCLT. Wait a second. An order made by NCLT was challenged in NCLAT. What the hell is happening? Wait. An order made by NCLT was challenged in NCLAT by ABC Limited within 1 month of passing of such an order by NCLT. In the meantime, during the pendency of an appeal, one of the party to the NCLT suit notices mistake in the order passed by the NCLT. So it basically says that if the mistake is apparent on record, then within 2 years the same can be revised by NCLT itself. All right. So according to the parties. Accordingly, the party files an application against the mistake for its rectification before NCLT. As per section number 420 of the Companies Act 2000 Companies Act, the tribunal may at any time within 2 years from the date of the order, with a view to rectifying any mistake apparent from the record, amend any order passed by it, and shall make such amendment if the mistake is brought to its notice by the parties, but no such amendment shall be made in respect of any order against which an appeal has been referred. So basically, it says that if NCLT passes an order and there is a mistake apparent from record, then the same can be rectified by the NCLT within 2 years. But if the same is appealed, if the order of NCLT is appealed to the NCLAT, then the same cannot be amended. All right. This is about this section. This is example. All right. So yes, my next example is about business of ABC Limited, a public company, is not being conducted and managed by directors in accordance with sound business principles or prudent commercial practices. The shareholders of the company has referred the same to the tribunal on 15 September 2019 with a request to the tribunal to inquire into the case and take action against the directors of the company. The tribunal has, after making proper inquiry, passed the orders against the directors. The directors के against order passed कर दिया on 16 March 2020. In the given case, order passed is not valid, as the tribunal have to pass order within 3 months from the date of application, and if not possible in 3 months, then extension may be possible. So basically, it talks about the time limit, about the expeditious disposal as per section number 422. The question this is an example only. The question, if it comes in exam, this will basically tell you that by what is the time limit, or basically tells you is the order valid. Then you can answer this type of question. So this example was basically vague, you can say, because it didn't ask us anything. It just gives us a case study basically. So we can't make much out of it, but you know how to refer to those sections, and I hope you have already learned the major chunk of this chapter. All right, so let's head to section number 424, which talks about the powers of the tribunal. So yes, section number 424, which talks about the powers of the tribunal. It basically says that there is a particular powers like which is always there in your all the subjects, like summoning and enforcing the attendance and all. This is there in your DT chapter, DT provisions, in your IDT provisions and your law provisions. Even in law, the Prevention of Money Laundering Act and all, SURFICE Act, there will always be these types of provisions there. And I hope you have already learned these 3 to 4 provisions. I'll give you a common list of these that you can always refer in your other chapters as well. All right, section number 424 is all about that. So yes, the tribunal and the appellate tribunal, that is NCLT and the NCLAT, shall not while disposing of any proceeding before it, as the case may be, an appeal before it, be bound by the procedure laid down in the Code of Civil Procedure 1908. Basically, it says that the appellate authority and the the appellate tribunal and the tribunal are not bound by the Code of Civil Procedure 1908, and they can only be guided by the principles of natural justice, as written over there, but shall be guided by the principles of natural justice and shall be subject to the other provisions of this Act or the IBC 2016. So NCLT and NCLAT shall have to follow the principles of natural justice plus Companies Act 2013 and the IBC Act 2016. So IBC, Insolvency and Bankruptcy Code 2016, they will have to follow. Plus, they are not guided by the Code of Civil Procedures. This is given in this section number. Plus, the tribunal and the appellate tribunal shall have, for the purposes of discharging their duties, so for discharging their functions under this Act or the IBC 2016, the same powers are vested in the civil code. The NCLT and NCLAT shall, for the purpose of discharging their functions under this Act or under IBC, the same powers as are vested in civil code. So they will have the powers of civil code, but they are not guided by the principles of civil code. All right, this is the main crux of this section. And while trying a suit in respect of the following matters, namely summoning and enforcing the attendance of any provisions, that is, the NCLT and NCLAT can summon any person and enforce the attendance of the person and examining them on oath. That is the power of them. Plus, they can require the discovery and production of documents. These are the common points for your other chapters as well. So remember that. Receiving evidences on affidavits, and this is the unique point, subject to the provision of section number 123 and 124 of the Indian Evidence Act, requisition any public record or documents. No, this is also the common point. You can refer this point in your other chapters as well. All right, it is about the Indian Evidence Act 1872. So basically, they are saying that subject to the provisions of section number 123 and 124 of the Indian Evidence Act, they can requisite any public recorded document or a copy of such a recorded document from any office. All right. So if NCLT asks any director about the public document, that is the annual returns, if any other particular document, financial statements and all, so they can ask from the directors about that. All right, and the director shall have to follow the instructions of the NCLT and NCLAT. They can summon and enforce the attendance, as I've already told you. They can require the discovery and production of documents. They can receive evidence on affidavits, and they can issue the commissions for examination of witness or documents. All right, so they can dismiss a representation ex parte. Ex parte here means ex parte actually means that if it basically means that you can dismiss a case without consulting to the other party concerned. All right, so you can dismiss a representation for default. So you can dismiss a representation for default or deciding it ex parte. All right, this is also the power of NCLT and NCLAT. All right, and setting aside any order of dismissal or any representation for default or any order passed by it ex parte. This is also the same basically. You can set aside the order of dismissal. First, in the F point, it was about dismissing a representation, and G point is about setting aside any order of dismissal of any representation. All right, and any other matter which may be prescribed. All right, so these were the powers given in section number 424 of the Companies Act 2013. All right, so yes, nature of decree and its execution. So basically, it says that if NCLT or NCLAT orders issues an order, then that can be basically enforced by the tribunal as if it is the particular order of as if it is the decree made by the court in a suit pending therein. Like it can be enforced by them, and particular they will have to follow. The company shall have to follow as if it was a decree of court. All right. So let's read it. Any order made by the tribunal or the appellate tribunal may be enforced by that tribunal in the same manner as if it were a decree made by a court in a suit pending therein, and it shall be lawful for the tribunal or the appellate tribunal to send for execution of its orders. That is, if the order was not executed by the company, then the same can be followed up by the NCLT and NCLAT to make a company execute its order by using the powers of law. All right. within the local limits of whose jurisdiction. So registered office here, in the case of an order against a company, the registered office of the company is situated, and in the case of an order against any other person, the person concerned voluntarily resides or carries on business or personally works for gain. All right. So I hope you have understood the part. So yes, next point is about nature of proceedings. This is not very important. We'll just give it a read. That all proceedings before the tribunal or the appellate tribunal shall be deemed to be judicial proceedings. All right. Now we will study this transfer of certain proceedings, certain pending proceedings, which is section number 434, the transitory provision, at the last, because it is not at all important and its practical applicability is not there. But we will study it, but at the end. All right. So let's head to the other provisions first. Yes, miscellaneous provisions. These are the miscellaneous provisions, but very important. All right. So I recommend you not to miss these. So section number 425 basically talks about the power to punish for contempt. Contempt here means the term contempt of court shall refer to the act of offense of being disobedient to or disrespectful towards the court of law and its officers in the form of behavior that opposes or defies the authority, justice and dignity of the court. So if a company or directors or any other authority that disobeys or is disrespectful towards the court of law, and then the same is called as contempt of court, then the NCLT and NCLT shall have the same powers as if it were a high court. All right. So basically it tells only those with the following modifications as well. Let's read it. The tribunal and the appellate tribunal shall have the same jurisdiction, powers and authority in respect of contempt of themselves as the high court has and may exercise subject to the following modification. The reference to high court here means construed as reference to the tribunal and the appellate tribunal, and the reference to advocate general in section number 15 of the said act construed as reference to such law officers as the central government may specify in this behalf. All right. So section number 425 was talking about power to punish it is in the same lines with that of the High Court. All right. Section number 429 then power to seek assistance of Chief Metropolitan Magistrate. So yes, let's read it. The tribunal, that is NCLT, may in any proceedings for winding up of a company under this act or any proceedings under the IBC. So winding up in the Companies Act 2013 or any proceedings in the IBC, that is a CIRP process, if that is being undertaken by the tribunal, then in order to take into custody, if they want to take into custody any assets or any documents and all, then they can take assistance of CMM. This only talks about those that take possession of such documents, books of accounts or other documents, and cause the same to be entrusted to the tribunal or other persons authorized by it. So they can take basically the assistance of CMM, CJM, Chief Judicial Magistrate or DC, District Collector, within whose jurisdiction such property, books of accounts or the documents of such company under this act or of the corporate persons under the said code IBC are situated or found to take possession thereof, and the Chief Metropolitan Magistrate, CJM or the DC, as the case may be, shall on such request being made to him take possession. So they will have to follow up. All right. So yes, for the purpose of securing compliance with the provisions of subsection 1, that is the above subsection, the CMM, CJM or the DC may take or cause to be take such steps and use or cause to be used such force in as may in his opinion be necessary. So they will have to take all those steps which they will have to require to do the particular task given by the tribunal. All right. So no act of the CMM, CJM or the DC done in pursuance of this section shall be called in question in any court or before any authority. So their act is the patthar ki lagi basically. So now let's head to section number 430. It basically says that civil court will not have any jurisdiction in respect of any matter which the tribunal or the appellate tribunal is empowered to determine. Basically, it says that if the NCLT or NCLAT are empowered to determine any matter, then the civil court shall not have any jurisdiction in those matters. All right. So let's head to section number miscellaneous but not important category sections. Section number 434 is also covered in this only, but we will cover that in detail because the length of that section is big, and we will cover that in detail only. All right. So we will give it a read only for 8th category section because these are not important as per my judgment. All right. So section number 426 basically tells us about the delegation of powers. Basically, it says that NCLT and NCLAT by general or specific order direct, subject to such condition as may be specified in the order, any of its officers or employees. So basically, the powers can be delegated to the officers or employees to inquire into any matter connected with any proceeding or as the case may be, appeal before it, and to report to it in such manner as may be specified in the order. Basically, very difficult to ask this question. Like it cannot be asked. You can say that. All right. Section number 428 says that protection of action which was taken in good faith. So suit, prosecution, or other legal proceeding cannot be lie against the tribunal, president, member, officer, or other employees of the tribunal at all, because if the same is if the action taken by them was in good faith. All right. So it just says that it protects tribunal and their members, appellate tribunal and the members, liquidator and all the other members. All right, which are authorized by the tribunal or the appellate tribunal for the discharge of these functions under this act, if the same was taken in good faith. All right. Section number 431 says that if there was any vacancy in NCLT or NCLAT, the same cannot be used against the NCLT or NCLAT. All right, for ground cannot be used as a ground for invalidating the acts. All right. So there is an example. You can read it very simple. All right. Section number 432 talks about basically a party to any proceedings or appeal before the NCLT or NCLAT. Basically, it says that legal representation can be done by CA, CS, and CMA, and lawyer as well. So lawyer or any other person. So in the previous 2016 era, only the lawyers, if it was the case of High Court, if the case was held in High Court for like compromise or arrangement sections were there, the same was held by High Court. Then the only lawyers can be representatives of this for this particular thing. But now, since the NCLT takes over this thing, then CA, CS, CMA, and any lawyer can also be CA, CS, CMA basically can be the legal representatives as well now, as per section number 432. So the same can be asked. Very lenient charges, but yes, very lenient charges, but yes. Okay. So section number 433 basically talks about the provisions of the Limitation Act, which is also applicable for the tribunal and all. All right. So it is not at all important. Limitation Act just tells us about the time limits and all, which is not at all relevant for our syllabus. All right. So let's head to section number 434 now. I have made a particular table summarizing section number 434 in all major aspects. So yes, this table can help you get over this fear of section number 434, which every person has. All right. I have made this table after listening to many authors as well, so you can trust this. All right. So yes, basically the general thing here is that every order which was pending before which was pending before the older authorities, for example company law board and the BIFR and all, will be transferred to NCLT. This is a general provision which is in our mind. All right. So but there are specific provisos as well, which talks about the winding up section, the IBC section, which says the other things, and we will study that as well. All right. Section number 434 subsection 1 clause B talks about the person aggrieved by any decision or order of company law board before such date. Such date here means 1st June 2016. All right. So person aggrieved by any decision or order of CLB. If CLB has already ordered that this is the order and the company shall have to do this thing. All right. Then if any person is aggrieved by that order, then the same can be appealed to High Court only. So High Court will be there in section number 420 to 423. We have not discussed any provision that is related to High Court. So yes, this was the exception. Section number 434, which was a transitory provision. So it talks about the High Court if the order is passed by the CLB before 1st June 2016. All right. So 60 days shall be there, and 60 days if further 60 days if sufficient cause is there, if HC is satisfied. All right. Only on question of laws. So section number 434 clause 1, 434 subsection 1 clause B talks about this. All right. 434 subsection 1 clause C basically talks about pending before any district court or High Court. If any order, any prosecution, any appeal is pending before the district court or the High Court, then the same shall be transferred to the NCLT. But now the provisos are there. The exceptions of the fourth exception to the section number 434 clause 1 subsection C are there, where we will talk about the winding up section and all. So let's completely focus on these points only. All right. So any party or parties to any proceedings relating to the winding up of the companies pending before any court immediately before the commencement of the IBC Amendment Ordinance 2018. So before the commencement of the IBC Amendment Ordinance 2018, and any party or parties to any proceedings relating to winding up immediately before the commencement of this IBC Amendment Ordinance, then the same can maybe file an application for the transfer of such proceedings to the tribunal. All right. Let's read it again. All right. Any party or parties to any proceedings relating to the winding up. So winding up, for example, the winding up is happening and pre-IBC Amendment Ordinance 2018 era. All right. So the parties here is companies, and the other party can be the High Court. Then if these two parties are against each other and the winding up is occurring, the winding up of the company is pending before the court. Proceeding to the So yes, basically it says that any party or parties to any proceedings relating to the winding up of the companies pending before any court immediately before the commencement of the Insolvency and Bankruptcy Code Amendment Ordinance 2018 may file an application for transfer of such proceedings. So it is a a section about the winding up of the company section, and it says that if any proceeding is pending before commencement of the IBC Amendment Ordinance 2018, then any party to the winding up, for example, the company, can file an application for transfer of such proceeding, and the court that is High Court, may by order transfer such proceeding to the tribunal, and the proceedings for transfer shall be dealt by the tribunal. So NCLT can handle these cases, and these proceedings can be transferred to the tribunal as well under the CIRP process. All right. So let's read it again to understand it better. So any party or parties to any proceedings relating to winding up of the company pending before any court. Any court means a High Court, District Court, and all. If they were all right. So if they were authorized, then if the proceedings were pending before any court immediately before the commencement of the IBC Amendment Ordinance Act, Ordinance 2018, that any party, for example, the court can also file an application, or the company can also file an application to the tribunal. All right, that the same can be transferred to the tribunal. All right. The application shall have to be filed with the court, and the court can order to transfer such proceeding to the tribunal. All right. So yes. Another proviso is there to section number 434 clause subsection 1 clause C, that says that only such proceedings relating to the cases other than winding up which are not reserved by the High Court shall be transferred to the tribunal. So it says that if other than winding up sections, other than winding up proceedings, all the other proceedings that are not reserved by High Court shall be transferred to the tribunal. And another proviso is there. This is very hectic to learn, so let's focus on this, and please do it from the table. If you will do it from any other source, then that would be very confusing, because even if I am teaching right now, this is very confusing section, and it is not so important because this is not practically implementable right now, but the institute, So yes, proviso, it says that all the proceedings under Companies Act 1956, other than the cases related to the winding up of the companies that are reserved for orders, or second point, the proceedings related to winding up of the companies which have been transferred from the High Courts shall have to be dealt with in accordance with the Companies Act 1956. So ये भी रट्टे वाला point है आपके लिए. All right. So next point is about proceedings related to voluntary winding up. If the voluntary winding up case is there, then it shall also be continue to be dealt with in accordance with the provisions of the Companies Act 1956, and the company has not been dissolved before 1st April 2017. So this is also a particular date which is needed to be learned. All right. So this is over, and this was the first point which I have made it for the last, that all the proceedings will be transferred to the NCLT. All right. I hope this is the crux of the section. I will recommend you to learn section number 420 to section number 423 in detail, and 424 also, because that can also be asked. And I hope you have already understood this chapter completely. Plus, I would recommend you to do, if you are doing section number 434, if at all you are doing section number 434, to use this table only. All right. You can have this PDF from my Telegram channel, and the link will be in description box, so you can connect on me on that Telegram channel as well. And my phone number is also there. Any query you can ask on my WhatsApp and all. So yes, I hope you understood it well. Thank you for showing the patience, and I hope you score good. And thank you so much for bearing with me. I'll see you in your next video. Plus, again, I'll recommend you to watch the miscellaneous provisions chapter. I've already covered 3 chapters, which is dormant company, and removal of name of company from the register of companies so far. And you can see the schedule as well, where I've told everyone that how many chapters I'm going to cover in this month of March only. All right. So yes, all the best. Thank you for your patience. Bye bye.